Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Riddell, and today I'm delighted to welcome Mr. Cornelius Sng. Graduating from the Singapore University of Social Sciences, he is admitted to the bar as an advocate and solicitor of the Supreme Court of Singapore. With extensive experience in cross-border family and probate law, Mr. Sng has successfully handled complex international disputes from child custody and maintenance to estate administration. He brings unmatched insight into navigating high-stakes legal challenges. His client-focused approach and sharp legal acumen make him a leading voice in family, estate, and civil law. So, Mr. Sng, to start us off, what initially inspired you to pursue a career in law, and what led you to specialize particularly in cross-border probate and family law?
First, I must thank you for my introduction. I think you really flattered me. And I'm honored to be able to do this interview for you. Okay, so what initially inspired me to pursue a career in law? Well, to be very honest, I've always felt I've got a penchant for languages, for linguistics. I was doing okay in mathematics and in sciences, but those were not things that piqued my interest. And I knew I would be rubbish at them if I pursued them in tertiary education. And so law became one of those things that I decided I wanted to do, especially after I've joined the debate team in secondary school, or what you would know as high school, right? I realized that I have the ability to think analytically, and I'm able to couch arguments and put them in a logical flow in a very short span of time. So I thought law would be the right choice for me to make. And so this is why I chose to go into a career in law. Why did I choose to specialize in cross-border family and probate law? I don't think this is something that I had a say over early on in my career. I think as a young associate, when I first joined practice, I was just being thrown whatever files that came my way I had to do, whether they were civil, they were criminal, partly commercial, drafting of contracts, whether they were family law. But I realized that unlike some lawyers in practice, I would think I've got more empathy. I'm able to empathize with my clients. And I think that when you deal with something such as family law, it is not so cut and dry. A lot of times you also have to deal with the emotions of clients. And with these emotions, they always have crazy expectations. And sometimes it's up to the lawyer to be able to manage those expectations. And I realized that this was something I could do. And so this is why I'm in that area of practice now.
Thank you for sharing your journey, having these different elements. Firstly, your skill set kind of being more law inclined, and then having your human skill set and qualities of being more empathetic, all interplay into, having your role today as a lawyer. So focusing in on cross-border probate law, for listeners who may not be so familiar with the field, could you explain what cross-border probate entails and how does it differ from other areas of commercial or civil litigation?
So when you talk about commercial or civil litigation, I think the name itself would give it away. If it's litigious, it means you have got two parties who are contesting a particular claim that is brought either by the claimant or who we used to know as the plaintiff, right? Whereas when you deal with probate matters in general, it could proceed uncontested, especially if all the family members are in agreement. Nobody is fighting over the asset of their dead loved one or family member. So that is where probate generally differs from litigation. Of course, probate can also be litigious, such as when a family member contests a will, or when an original will cannot be produced and you need the court to go into some fact-finding exercise to determine the intention of the deceased. So that is generally the difference between probate and litigation. Now, specifically to cross-border probate, it just means that we deal with foreigners who have assets, real estates, movable, immovable assets here in Singapore that would require distribution after they pass away. So that is what cross-border probate law is about. Yes.
That's a really clear breakdown of cross-border probate law and also specifying how it may be litigious sometimes. So since your work often spans multiple jurisdictions, how do you handle the cultural and legal differences that come up during the process?
So let me just deal with this on two prongs. Let me first look at the legal differences, right? So given that Singapore is a Commonwealth country, if we have gotten a grant of probate or a grant of letters of administration, or say we've gotten an order of court from a Commonwealth nation, then it is very easy to enforce the judgment here and have it recognized here. Alternatively, you can have it resealed here if it's a grant of probate. However, when you deal with countries such as China, who are neither a signatory to the Hague Convention, say for example in child abduction cases, or when you have an order of court from China on the matter of inheritance, because you cannot reseal their papers here, and also because the Reciprocal Enforcement of Foreign Judgments Act does not apply, then it is entirely at the discretion of the courts to determine the matter on its merits. However, as we have seen from precedent cases, how we deal with it legally and the submissions that we make as lawyers would always center around the fact that we would want to respect the Committee of Nations. Usually courts of other competent jurisdictions, when they make their findings, it is very unlikely for the Singapore courts to disturb those findings, especially when the people that the matter concerns are domiciled in, say, that foreign country. So that is the legal difference part of it. Cultural difference, actually, because of globalization, you realize that people are much smarter than they let on these days. However, you still have that odd fellow who walks in, and not so much cultural, but I think they are too bought into sensationalism of television shows, right? And so when they watch something and they realize that I am the successful party or the victorious party in, say, a legal suit, I'm entitled to all my legal costs and the other party has to pay me. So I think that is the problem that we face with actually a lot of litigants that come in. They always think that they are entitled to full legal costs, but that is not the framework of Singapore, and I think it is up to the lawyers to manage those expectations. I think globalization has helped us to soften or to at least blur the lines between what we used to generalize as cultural differences in terms of how people perceive things or perceive how the legal jurisdiction would work.
That's a really insightful point. And, talking about not just the legal differences within Singapore, however, you also have cultural differences with, the growth of TV shows and movies kind of affecting maybe how some behaviors might be. So adding on to what you said a bit about globalization, how do you think globalization will affect cross-border probate law moving forward? Maybe some trends that you're suggesting or looking at?
I think globalization in general has already affected probate law, and I don't think just probate law, but law in general. Because you see, the law is one of those things that is reactionary, right? It is one of those things or those frameworks that every country has, that every competent jurisdiction has, that will always change and adapt to your new social fabrics, to how society is like. Say, for example, the temporary COVID measures were quickly taken up and signed into legislation by Parliament when COVID hit, right? So this is how alive the law is. But I think particularly to globalization and probate, because of globalization, people are more aware. People are also more comfortable putting assets in different countries because they want to safeguard their assets and they don't want to put everything into one same basket. It could also be because if you keep your assets here in one country, your taxes are incredibly high. And so this is how globalization has affected probate. So now I deal even with, say, Singaporeans. You'll be surprised when I take out probate papers for Singaporeans, right? A lot of times I deal with extraterritorial assets as well. And similarly, I have got a lot of foreign clients who come in who have assets here in Singapore that require the court's order for distribution. So I think that's how globalization has interplayed with the law in general.
Speaking of how different people might put their assets in various countries, kind of adding on to that whole idea of globalization and interconnectedness between the world, how do you feel that conflicts between different legal systems get resolved in cross-border probate law?
How do conflicts get resolved in cross-border probate law? Okay, without coming across as being too monotonous and as an academic, I have actually alluded to it a bit earlier. Generally, the conflicts of law would not really arise if there is that principle of Committee of Nations. So if I've got two China clients who come in and they are contesting the validity of a will, for example, if the formalities of that will do not comply with the formalities as required by Singapore, then obviously in Singapore, it is a no-go, right? But say this will was actually signed in China and the Chinese courts have already examined the will and they determine that this will is authentic and is binding. Generally, when they bring their papers to Singapore for enforcement here, it is unlikely that the Singapore courts again would disturb the findings of the Chinese courts with regard to the authenticity of the will. And so the distribution would ordinarily follow the domicile of the parties involved. One of the more recent cases I have done, though not probate, it is also a family law matter. Because of, like you said, globalization, right? So everybody is going everywhere to work, children are going everywhere to study, and now getting out of country to escape the jurisdiction or the grasp of a particular country's courts have also become easier. People are smarter, they try to move around. Resettling somewhere else, completely new, has also become easier. So I've got a client who came to me asking for help because her son was taken from her by her ex-husband, and he unilaterally brought the son into Singapore. Now, this must be seen in context of the fact that this was defying two Chinese court orders. Right? So although we took up papers here in Singapore and we did canvass the foreign judgments to the Singapore court, it is not so much a recognition of the foreign judgment, but to canvass this as part of the evidence that this matter has already been heard, has already been tried, and that the Singapore courts should not dabble too much into the nitty-gritties of the case, but look at it from an overall context, such that we do not want to incentivize others like-minded folks, right? If they want to find a loophole to escape a particular court order, to come to Singapore and have it legitimized here. So that's the kind of message I think that lawyers and the courts in general are trying to dabble with. It's a learning journey, it's still a process, right? Yes.
I honestly love how you broke that down. Just talking about, firstly, just moving on from the Committee of Nations and just having that on its own on a national level be so significant. And then you move on to a more personal level and individualized level.
Yes.
So it all just kind of depends on the case, and it's just kind of case to case, I think, as law is.
Yes. So law is very, very fact sensitive, right?
Yes.
You can have 10 people coming in for a divorce, and all of them can cite unreasonable behavior of my husband. But every single one of those cases would be different on their facts. And that's what makes law so interesting. So all the marriages can be dissolved on unreasonable behavior, but each of those unreasonable behaviors would warrant different distribution of assets, possibly. It would also stir different kinds of emotions between parties. And they're all fact sensitive.
I think that's a great segue into another one of your specializations, family law.
Yes.
So what may be some ethical dilemmas that you see often arising in family law, and especially cross-border family law?
Ethical dilemmas. I think as a lawyer, your yardstick when you take on any kind of case is to always be ethical. And I think this is something that we all learn in law school. We have to learn to put our own personal preferences aside. That's the first thing, right? And you want to look at the case objectively, and you want to advance your client's interests as best as you can within those parameters. You do not want to get too vested in a matter and have too much interest in a particular matter, right? Such that you get emotionally affected all too much. Then that would again blur the lines between your professionalism and how you actually handle the matter altogether. What kind of ethical dilemmas I face? So, say the most recent matter that I did in the High Court. I must tell you from a very human perspective, after having met the father in court during the appeal before a justice here in Singapore, I must tell you that the father who unilaterally brought the son into Singapore, I don't deny for a moment that he loves the son. I certainly do not deny that. After all, he's lived with the son here for close to 2 years. But a court order is a court order, right? And the Chinese courts have deemed it fit that the mother should be the primary caretaker. Although the mother has also got lesser earning capacity, the courts have recognized that the child is young and requires dependence on the mother, has got endless dependence on the mother, whether it's in terms of nurturing his growth, his development, so on and so forth. The Singapore courts here obviously agree. And so what we got from the judge in our favor, thank the gods, was for the child to be handed over to my client forthwith. And this would mean the handing over of a child of a cross-border family dispute outside the courtroom. And you can imagine the kind of chaos that ensued. Because the child is still young and he has depended on the dad, he does not understand the circumstances of the case and why things are like that. When we took the child from the father, the child was wailing, crying, and screaming from the 6th floor of the Supreme Court building. You could possibly hear him from the 1st floor. So security guards and everybody came to the outside of the courtroom to facilitate the handover. The human side of me, my heart ached for the father because no matter what, he is a parent. But on the ethical side of things, or at least on the legal side of things, my client should not be denied the fruits of her labor in litigation. So I think that is the kind of mentality you must have when you go into dealing with these kinds of cases, whether cross-border or whether local. I hope I've answered your question.
Yeah, you definitely did. And I can imagine how difficult it would be in that situation, not just as a lawyer, but as a client in that situation.
Yes.
Dealing with the whole legal aspect of things, as well as balancing emotional regulation, is such a hard task. And it takes a lot of time to really, get used to that feeling, I can imagine.
I don't think you can ever get used to that feeling. To be honest, I don't think it's something you can actually get used to.
Yeah.
But it is something that you learn to put aside in a professional capacity. And I think that's the makings of a good lawyer, right? Because you want to be able to be objective.
Yes. Well, adding on to maybe child custody, what are some of the most common challenges that you see in international custody or maintenance disputes?
So custody is one thing. Usually the aggrieved party or the aggrieved parent who has not been awarded child custody would find themselves in a pickle, but like the case I cited earlier, when they decide to take things into their own hands and take the child and run away.
Mm-hmm.
The reason why I can understand people do this is after practicing for a while now, Singapore is such a small country. Say, for example, if daddy gets custody of the child, it simply means, or can control of the child, it simply means that daddy lives in Tampines and mommy probably lives in Punggol or in somewhere in Singapore. But even to the far ends of Singapore, say even to Jurong, from Tampines to Jurong, it will take you for the better part of an hour by train to get there. And it is always accessible. Now, what happens if you live in a country like Malaysia, like the UK or China? When mommy lives in Beijing and daddy lives in Shantung, or when mommy lives in Johor and daddy lives in KL. Now, you have a problem with custody because access to the child has become more difficult, right? And so this is the reason why you can see sometimes foreign clients, when it comes to cross-border disputes, they are more hell-bent on their positions that sometimes we Singaporeans do not see because we cannot understand that kind of plight, right? So I think that's as far as custody goes. So that's one of the challenges when you deal with clients like that. And I think one of the ways that we can try to soften grounds a little bit is with the proliferation of technology. Luckily for us all, that even if I cannot have physical access with my child, you can always talk your client into saying, you know what, primary care and control can go to your wife. Doesn't matter that you are in a different state. We can always make an arrangement for them to come and spend the summer holidays with you. But maybe on a daily basis, you get 30 minutes video call. So you don't lose that connection. So at least with the proliferation of technology, these alternatives are possible. So that is as far as cross-border custody would go. Cross-border maintenance. Cross-border maintenance is again one of those very sticky things, right? What exactly is enough? In Singapore, the cost of living here is higher than, say, China. So what happens if the child gets enrolled into a private international school here? What the Chinese court orders for 500 Singapore dollars a month for the maintenance of a child would hardly be sufficient to upkeep the child here. So this is when parties are always at liberty to take up a variation application in the courts, either in their country of domicile to inform the courts that this is what has happened, there's a material change. You get them to vary it. And if you want to use it in Singapore, you can get it recognized here or enforced here, or at least take up an application here. In the alternative, if you have lived in Singapore long enough, we always give clients the option of taking up a variation application straight away with the Singapore courts here, if you've been habitually resident. So those are the challenges we face, I think, with custody and maintenance of children in general.
That's quite a thought-provoking perspective, and also just seeing again how technology keeps persisting in our digital world, in our kind of ever-changing world, having it be a way for parents and children to communicate despite, geographical boundaries and borders. It's making our world more accessible.
It is, yes. And I think it is important that lawyers also learn to keep up with the times and we learn to change our mentalities towards such things. So we always ask ourselves, especially when it comes to issues of custody or child guardianship, what is in the best interest of the child? Just because my client wants the child and he cannot bear to be physically apart from this child for such extended periods of time, is the child really going to be is the child's best interest really going to be best served if he remains with my client who travels for work 3 times a month, who works from 8 in the morning until 7, 8, 9, 10 p.m. in the middle of the night, right? So at least, like you said, with the proliferation of technology, you soften these grounds. Yeah, you make parties come to a compromise more easily, I suppose.
Yeah.
Right, yeah.
I think that just goes back to, having this ethical dilemma again of, who gets custody of the child despite these kinds of arrangements. It's at the end of the day, who's better suited to kind of take care of the child.
Yes.
So adding on to our discussion about emotions, I think we did discuss this a lot.
Yes.
How do you balance supporting clients through their emotions while still focusing on the legal and practical aspects of their case?
I think as a lawyer, first and foremost, you have to discharge your duty as an advocate and solicitor.
Mm-hmm.
You have to tell them things as it is. Sometimes it is hard to say certain things, but you have to do it because you are duty bound to do so. However, given those circumstances, you try to see how your client's interests would best be advanced. What are the strategies you can take up? In terms of emotions, I think you must also remind your client that you are human and that you're able to empathize. If you are going to go into an interview with a very, very emotionally distraught client, with a poker face and a straight face, chances are the client is going to walk out without even appointing you as a solicitor in the first place. I think part of client management these days is also the ability to manage the client's emotions. That's one. But more importantly, and above and beyond just managing their emotions, with that comes managing their expectations. So once you can put things into perspective for a client, I think as with all humans, right? You will probably have the clarity of mind to think better and to make better choices or more informed choices. Chances are, I can tell you, with most clients these days, or most people these days, you probably know what the best answer would be. You just need a third party to validate it for you. And this is the same for most clients that you face, right? But again, I would caution against being too emotionally vested in a case. I've had peers who have been in practice for a couple of years, and they get so drained and emotionally drained from all these family cases because they just cannot seem to put it past their own emotions, who have now since left practice. Right? So again, it's always that fine balancing act. Yeah.
Yeah.
Yes.
That's a very valuable insight. Just separating your professionalism from your emotions and having that boundary be quite distinct, even though there are, many facets to the emotions, which I think is just many facets about the job as a whole.
I would think that law in general is technicolor, right? Because you've got so many different levels, so many different landscapes, so many different areas, and so many levels of complexity. But I think particularly when you deal with the areas of law that have a direct impact on humans, forget the commercial litigation, forget shipping, forget insurance law, for example, right? When you deal with things that really, really does not just come down to dollars and cents in the form of a monetary compensation, when you deal with emotional beings in a family lawsuit or a criminal lawsuit, that is when you have to not only be professional, but you have to be empathetic, right? So it's not so much putting your professionalism and your empathy or how emotional you can be into two very distinct and separate crossroads such that they do not cross paths. It is a matter of being able to discern and allowing these two values to intertwine. But you should never lose sight of one for the other.
Yeah.
Yes.
So that kind of definitely sums up, your role as a family lawyer and a cross-probate lawyer.
Yes.
So I just want to ask you, what are some of the most rewarding parts of your job? We talk a lot about human interaction, having empathy. So I was just wondering, what are some of these kinds of aspects which you feel rewarded from coming to your job every morning?
I think it's the kind of value you can bring to your clients. That is the most rewarding part. If your client walks away with what he or she wants, right, and you've gotten it, through the courts or through mediation, you would feel that what you do is worthwhile. And even if they don't walk away with what they want, but a middle ground or a compromise has been reached such that your client is not so unduly prejudiced by the other side's incessant or aggressive behavior, that is also another very, very rewarding part of your job as a lawyer, right? And the most rewarding part of it all, I suppose, is that years and years down the road, even though you no longer have this case file with you, you might have filed it away in your archives or in your stores. But the decisions that you have helped to make at that material point in time, or the order of court they have helped to obtain at that material point in time, would affect them for the rest of their lives. And for those reasons, when they look back, they will always be grateful to you in some way or form. The same way that I'm sure we as humans are grateful to the people who have helped us along the way,
Yes.
although we may not talk about it all the time. You will think back and realize, I remember this person.
Yeah.
Yeah, I'm in this predicament because of him or her. And I think that is the most rewarding thing that you can ask for as a solicitor.
And I think that's so meaningful, just bringing value to your client and just, helping them throughout this process. It might be a little bit emotionally disturbing. However, you're still there for them, not just as a lawyer, just clocking in a 9 to 5, but more than that, like a human there for them to kind of share and express their emotions with.
Yes, but I must caveat at this juncture that most lawyers do not work 9 to 5. We usually work overtime, especially when we have trial and whatever else coming up. But you are absolutely right. And that's something I've learned early on in my practice. It is the value that you can bring.
Yeah.
Yes.
Speaking of jobs and career paths,
Yes.
what advice would you give to aspiring law students wanting to pursue a career in cross-border probate and or family law?
First, be empathetic. Because this is something that law school will not teach you.
Yeah.
This is something that you must have. If empathizing with other people is difficult, then you might be more suited for something a bit more paperwork-based, maybe commercial litigation, something less emotional. If you find that you can be empathetic, then the next thing that you want to do is you want to learn how to be tactful. So empathy is one part, tactful is another part, because how do you break bad news to somebody? Chances are, if I go to you in a commercial litigation and tell you, they have frustrated the contract, the company is going to lose $2 million. It is much easier than going to someone and saying, hey, the courts have awarded your husband full custody, care and control of your child. So I think having tact is another thing. And third of all, I think you must not just have the attitude, but most importantly, the aptitude, right? Which I think is a prerequisite for all law students and all aspiring lawyers. Have aptitude, be empathetic, and be tactful.
Those are 3 brilliant takeaways,
Yes.
and it's very clearly broken down.
Yes, and no matter how far along you get in your career, these 3 things will see you through for the rest of your career.
Yeah.
Yeah.
That offers so much clarity for all our listeners here.
I hope.
It's been such a pleasure having you on this podcast, Mr. Sng. Thank you so much for sharing your insights. And to all my listeners, court is now adjourned until next session with the fine print.